A very good morning and welcome to our Tuesday program, The Legal Matters, whereby we deal with various matters regarding to some legal issues here and there. Welcome to our program for this week. And today we are talking about the employment and labor laws, whereby we need to see your rights regarding to employment and your rights regarding to labor. And today we are having the Advocate of High Court, Wilfred Konosi, who is here with us to be able to help us to put into perspective on this matter. Today we are asking you one question. Which labor laws or rights do you need, do you feel we need to change? Which labor laws or rights do we need to change? Yani, ni sheria gani za wafanyikazi ambazo nahisi kwamba tunaweza tukazibadilisha? Leo tunaongea kuhusu sheria za wafanyikazi na labor. Tuko na wakili wa mahakama kuu Wilfred Konosi kuweza kuangalia masuala haya, na vile vile tuko na masuala mengine ambayo tutakuwa tukiangalia siku. Kwa hivyo karibu sana mpenzi mtazamaji, tuweze kuwa naye mpaka mwendo wa saa 6 katika kipindi cha siku ya leo kuhusiana na mambo ya sheria. Niko na mwenzangu Mangicho Mola ndani ya studio.
Nashukuru sana mwenzangu Kagi, na natumai uko mzima. It's a beautiful morning to see you on this legal Tuesday episode of the mid-morning pack, hoping that you're having a great week. Did you plant some trees yesterday?
It was a busy day. I found my time in the suburbs of the city.
Okay.
But I managed to get one.
Wow. But
planting trees is a continuous process.
Yeah, sure. The government was targeting 150 million trees by yesterday.
Yes.
I'm told that there is an app that they are using to see or to find out and confirm whether we hit that particular target. We later on maybe be in a position to be informed on the same. But I'm also doing well, and of course happy again to have this particular episode of the Legal Tuesday, where we educate our viewers, we educate our audience, we enlighten them on various matters pertaining to the law. Actually, law is just a very integral part of our lives. In one way or another, we are affected with matters to do with the law, and that is why it is important for you to know when maybe you're taking a particular action, maybe when you're preparing to do something, how will it affect others in relation to the laws of the land. And that is why we are here again today. And just like Kagi has already informed you, we are talking about employment and labor laws. And of course, Kagi, it's quite an interesting subject because in one way or another, we are all affected by employment. We are all affected by labor. The labor force is a major ingredient in this particular society. So we are hoping actually to get a lot, even from our guest, Wakili Wilfred Konosi, who will in a short while be here also to tell us what we need to understand and to know about this particular matter.
Correct. And as usual, at this juncture, I want to introduce a small key regarding to our topic today, the employment and labor law.
Sasa kampuni inaweza ichaji. Sasa hata wati mimi hata kama sijaribu hata yangu, mshahara bado itaingia. Mimi waacha hivyo. Savings zangu nimeweka hapa. Na unakumbuka boss akituambia, wewe nyinyi keni pesa zenu at least itawasaidia. Please nyinyi mtaenda kuuliza loan, at least mtaenda na jina ya nini? Hata ile nini za kitu job kipozi unapewa. Sasa tutafanya nini? Na si ndio zile sign post. Na nimepita pale chini saa hii asubuhi ni kitu. Tuwapigie tuone kama jaribu tuone kama tutafanya, si ndio? Hii manzi juu ni mchezo. Hii hapana. Wacha tuone. Ni savings zangu tu hivyo man. Wacha tuweke na mstika ndio tusikie. Usikie kama ni yeye. Sikie. Imeenda. Imeturamba manzi. Imeenda. Jaribu tena. Achana na sasa kama imekataa nini bro. Sasa tufanye nini? Kwa sababu sasa we don't have a means, savings zetu ziko potea zote. Pension zetu, leave yetu iko hapa. Mimi hata nini kesho ndio nilikuwa nimemaliza nini leave yangu. Na nikasikia mtu akiniambia sign post zenyu zimetolewa. Sasa kampuni inaweza funga aje bila? Is this even legal? This is not legal. Hai. Hivi. Ndio kunywa kachai. Na pesa gani? Na pesa gani? Huwezi kosa bro. Ni kama madharau.
And I really pity for those two guys. Whereby you are waking up early in the morning,
Yes.
And to go to work.
Yes, although one of the actors, Kagi, there is saying that I don't know whether it is a friend of him that had told him that it's like they haven't seen the signpost.
Coming over.
Of their company or organization.
Yeah, there are many companies which are behaving the same,
Yes.
whereby you have invested all your resources and even time only to wake up in the morning, the company is not there. You have really maybe saved some money with them.
Yes.
And done a lot of investment, only to wake up and see the company is not there.
Yeah, and what does it mean that the company had not given any notice, had not given any information, has not communicated to its staff?
Yeah.
What kind of a situation is that you can just wake up to go to your office and you find that your office is not there without any information?
Yeah, and sometimes I think the public need to understand which are the procedure
Yes.
and the law regarding to maybe if you want to be employed somewhere. There's some things that you need to check before you allow yourself to sign any contract in any organization.
Yes.
And I think that is where the problem is with that those two guys. Maybe they didn't even take time to understand if the company is legally operating. And sometimes, Mangicho, though Wakil is around, I ask myself, how do you go to verify if the company is legit,
Yes.
is legal?
Sure.
Because you can't go and ask someone, maybe you are very desperate to work, and ask someone, excuse me, before I continue, may I see your documentations to verify whether your company is legal?
Yes.
It's not possible. But we need to have a way, if you're going to employment somewhere, to verify if the company is legally operating.
Sure.
Yeah.
Quite important, quite pertinent, because, and I agree with you, that might be one of the exercises that maybe very few people undertake. One of the reasons maybe is because of the desperate kind of a situation that maybe most people find themselves in when maybe they are they are seeking for these particular jobs and these particular employment opportunities. So when some of these scenarios take place later on, that is the time that they begin to regret. But as you've said, Wakil is here. He will help us understand.
Good morning,
Yes.
Wakili.
Morning.
How is your morning?
It's good. Yeah.
I think for some time you are doing well. Maybe 2 weeks. We have not been
Yeah, 2
together.
weeks. Yeah, 2 weeks. I wasn't able to make it last week.
Yes.
Yeah.
Yeah, Mangicho is here. You can say hi to him.
Thank you, Wakili. Karibu sana. Good to have you. And thank you so much. We had Lillian.
Yeah.
She did some very good work. Take our many thanks to her.
Yeah.
We are happy to have you.
Yeah.
Yes.
And maybe Wakili, because we had a small skit there.
Yeah.
I don't know what is your observations regarding to that.
Number one, I think I take two positions. One gentleman was complaining about having lost his savings.
Yes.
It was not quite clear whether he was a worker or somebody who had saved with something like a SACCO. And then you wake up in the morning, you go there, the SACCO is closed. And one of them, I think, was a worker. You wake up, you're going to work, and then you find that the office is closed. No notice. Then you wonder what to do. Well, there are very few cases when a company can just close offices without notice, and there are legal ways of following that up. One of them is when a company becomes insolvent. So that way, even if the doors are closed, we have a way in which a receiver is appointed to manage whichever assets are there for the company. And then once a receiver has been appointed, they give priority to what we call secured creditors. So those are the people who will get preference in getting payments, whatever the company owes them. When it comes to workers, there's a process which we call redundancy, where workers are declared redundant.
Yes.
And again, that one, the procedure to be followed is provided for under Section 40 of the Employment Act. For instance, the company should give notice to the affected workers. declare the extent of redundancy, send that notice to the labor officer. If the employee is a member of a union, send a copy of that notice to the union, pay them 1 month's salary in cash, and then pay them an equivalent of 15 days wages for every year worked, for the year they have worked. Yes, so there's a procedure.
And maybe when the company is put under receivership, is it that they have obligation to put the workers in redundancy, or they can still retain them?
No, when a company is placed under receivership, then obviously the receiver will evaluate the workforce and consider whether he or she requires the entire workforce to enable the company to remain afloat.
Right.
If the receiver doesn't require all the workers, then the receiver will start the process of declaring the workers redundant. Yeah.
Okay, before Mangicho comes in, there's an issue of you're going to get employment in a company.
Yes.
And you're not sure whether this company is legally operating. Is there a way I can be able to verify whether it is company is there legally?
Yeah, there are many ways of verifying the legal status of a company. We have what we call the company's registry. You can go to eCitizen, go to business registration, and search the name and see whether the company is legally registered. You will get a form called a CR12, which contains the directors of the company.
CR12?
Yeah, CR12.
It's just open, you can get it direct?
Yeah, you pay 650 shillings.
Or 650 shillings?
Yeah, and it's automatic. The system is automated, and you get it at the click of the payment. So it will show you.
Need to travel to the office of the registrar of companies.
You do it from the comfort of your computer.
That's good news to me.
Yeah, and then of course there are things like the local licenses. Yeah, from the counties. You can find out whether this company has taken out the licenses. But the most critical thing is to go to the company's registry and find out the status of the company. You can also find out the status of partnerships. You can find out the status of, what do we call them, sole partners. Yeah. Okay. For sole partners, it's CR13. Same with partnerships. So you can actually get a CR13 which shows you who is the owner and whether that business is legally registered.
All right.
Wow, that's quite interesting, and I think very, very important information there. And I know we'll be coming back to that because, Kagi, that is an area, especially when you talk about termination of duties, redundancy, and so many people have been affected. And maybe Wakili will still weigh in on that. But I remember even when we were talking off air, Wakili, you said that there are quite a number of laws pertaining to the employment and labor laws. There are quite a number of acts. Maybe if you can educate our viewer. Yes. But of course, I think for this particular show, maybe we'll restrict ourselves maybe to the main act, that is the Employment Act. But you can just give us a highlight of the 5.
Okay. Our labor laws, number 1, are anchored in Section 41 of the Constitution, which provides for labor relations. We then have 5 acts of Parliament which govern labor laws. Let me call them 5 main acts which govern labor relations matters in Kenya. The first and main act is the Employment Act. And number 2, we have the Labor Relations Act. And number 3, we have the Labor Institutions Act. Number 4, we have the Occupational Health and Safety Act. And number 5, we have the Workmen Injuries Benefit Act. Those are the main acts of Parliament which govern our laws. Of course, we have these other ancillary acts like the NHIF, NSSF, the Income Tax Act. They have an impact on labor issues, but not major like the 5 acts which I've mentioned. And again, on top of that, we have ILO conventions which Kenya has ratified. Those also by dint of the provisions of Section Article 2.5 and 2.6 of the Constitution, they also form part of our laws. So you can see that we have quite a wide array of laws which are applicable when we talk matters labor, matters employment. Yeah.
Well, that's beautiful, and I think maybe we'll see how maybe time will allow us, because I can see actually all of them are very important, because even when you talk about occupational health, the health of workers are very, very important. What happens to them when they fall sick, when they are incapacitated, and so on and so forth. But if we can just start, Wakili, with the Employment Act, the significance of this particular act, and also maybe even as you get deeper, how are individuals, how are people supposed to be employed?
When you're getting employment, the Employment Act provides that you can enter either into an oral agreement or into a written contract of employment. So the fact that I do not have a written contract of employment does not mean that I am not employed. I can be able to prove it in court that I entered into an oral contract of service. There are some contracts.
What will act as the evidence in the oral one?
In the oral one, for instance, evidence of payment of wages and salaries.
Wow.
Yeah, you've been paying me salary. Yeah.
Wow.
And then you are required as an employer to keep records of all the persons you employ. So if I make an allegation that I've been your employee, the burden of proof shifts to you to show that I was not your employee. Yeah, because the law requires that you keep records.
Okay.
So the court may ask you, can you bring the records of all your employees? And if you fail to produce those records, then the assumption is that the employee is telling the truth, that he was or she was your employee. Of course, when you have evidence like payment of wages and salaries. Yeah.
Wow.
When it comes to a written contract of employment, of course, there are several things which the law requires that they be included. Your name, your age, your gender, it will indicate your place of work, it will indicate your salary, and all those details. Yeah. And where you are a member of a trade union, the collective bargaining agreements form part of the terms of your employment. And sometimes you'll find that the collective bargaining agreements have better terms than those ones contained in the Act. But the law provides that where a company has recognized a trade union and they have registered a collective bargaining agreement, the terms and conditions contained in that collective bargaining agreement then form part of the terms and conditions of employment for all the persons who are employed within that institution. Yeah.
And maybe I've mentioned several areas that someone needs to check, or the employer, regarding to bring someone on board. But I'm asking myself, what are some of the basic needs that, as an employee, I should make sure that they have been incorporated, maybe when I'm reporting to work for the first day?
Normally what happens is, if a post is advertised, of course they'll give you, what we call it, they'll give you a synopsis of what the duties entail. And once you succeed, they'll give you what we call a letter of offer. That is a letter of employment. That letter will contain, in summary, your duties, your salary, and what is expected of you. And of course, not everything will be contained in that letter. Yeah. So they'll tell you, for instance, if it is issues of discipline, They will be contained in the human resource manual, which is available. But the letter normally contains a summary of what you expect. Yeah.
And maybe when someone is being employed, we have things like the probations. Where do they come in?
The law provides for a probationary period of 6 months, which can be extended for a further period of 6 months, but with the consent of the employee.
That is 1 year.
Yes. And then the interesting thing is that when you are under probation, if the employer wants to terminate you, then the notice which is required is 7 days notice.
7 days notice?
Yes.
Within the probation?
Yes, when you are on probation. Yeah. So the employer can give you 7 days notice and tell you now, I no longer require your services. After the notice, pay you your salary or your wages, and you call it quits.
Okay.
Yeah.
I go back a little bit. You have talked about probation for 3 months.
No, 6.
6 months.
6 months. Yeah.
They can be extended to another 6 months.
Yeah.
What wisdom brings you to be pushed to another 6 months? Why not 6 months and then you verify that you can be employed?
No, the extra 6 months is with the consent of the employee.
Yes.
Yeah, it's okay, but I'm still wondering, why should they extend? Is it that they have not verified your performance, or they are not really sure that they are going to give you employment? Why extension?
What would make the employer to extend the probation? After the 6 months.
That means they are still evaluating you to see if you are fit for that position. Yeah.
Wow, that is interesting. And okay, just as Kage said, when one is being employed, we know there are those terms that we've talked about, and there are those who are maybe employed on contract, there are those maybe who are employed maybe on permanent basis. We also have others maybe who are on casual basis. How does this go in relation to the law? And there are people maybe who are employed, but they do not have. Is it mandatory for you as an employee to be told this is the term of your employment, and maybe even given a written document showing the same?
Yeah, like I mentioned earlier, you can have an oral, you can enter into an oral contract for employment. Then you do not need to show a written document. You've mentioned something very interesting, which I think we need to talk about. We have various types of employment. Number one is permanent and pensionable. We have casual employment. We have what we call piece rate employment. We have part-time employment. So there are several types of employment. We have seasonal employment. So it entirely depends on...
there are factors that will determine when is supposed to be employed maybe on either of those.
Yes.
Is it the sole discretion of the employer?
Yes, it is. Because as an employer, I'm the one who decides. I want a part-time employee. And I'll give you terms for that part-time employment. For instance, universities have what we call part-time lecturers.
Right.
Yeah, a part-time lecturer will be employed. You teach this course for this semester, mark your examination, we pay you.
Yes.
The relationship ends there.
I'm done with you.
Yeah.
Yes. We only require you to see you here Thursday and Friday between 12 to 2 p.m.
Yeah. Administer your examination,
yes.
Mark the papers, give them to us, we pay you. That is the end of that engagement.
Wow.
Yeah. Wow. When we talk about casual employment, the law provides that casual employees are people who work on a day-to-day basis, and they do work which is likely to be concluded within 1 day. And they paid their wages at the end of the day. Before 2007, before the new labor laws came into operation, we had an issue with casual labor. You would get companies which, for lack of a better word, would employ people on a casual basis, yet they are working permanently. And what that then meant was that if you are employed as a casual worker or as under contract of, say, 2 months or 3 months, renewable, that meant that you lost your benefits like annual leave, maternity leave, and all those other benefits. Because as a casual employee, you are not entitled to those benefits because the law defines you as a person who works for a day, and you're paid at the end of the day. Yeah.
So if you fall, as a casual if maybe, for example, you're going to visit somebody or God blesses you and you are expectant, that's the end of your job.
Yeah. So the new labor laws now came in to address that issue and actually stated that if you are employed for a period of 3 months continuously, then automatically your employment is converted from that of either on contract or casual to permanent and pensionable.
So you'll no longer be a casual laborer?
No, you no longer.
So long as you've been in that particular organization or company for
3 months.
3 months.
Yes.
Okay.
Yeah. So that issue actually addressed the perennial problem we had with the issue of casual laborers and employment of contracts of normally 3 months, renewable after every 3 months, Yeah.
Wow, that's quite interesting.
The issue of trade unions.
Yes.
Where does it come in? Because you find that many organizations, depending on the employability, they are trade organizations. Now, where do they come in legally, and where do you think we can be able to allow people to join their trade unions? I think before you continue, let me just remind them about the question before we go for a short break.
Yes.
I think our topic today, dear viewer, is employment and labor laws. We have Wilfred Konosi, who is advocate of the High Court. And today we are asking you one question. Which labor laws and rights do we need to change? Which labor laws and rights do we need to change? Our SMS number 23814. 23814 is our SMS number. WhatsApp SMS number is 0721 105 105. Today we're talking about employment and labor laws. Which labor laws or right do we need to change? Text us on 23814 0721 105 105. And today we are talking about the issues of employment and labor laws. But basically today we are concentrating on the Employment Act. If you have any question regarding to employment, our advocate is here. You can ask your question, Wilfred Konosi, and he is very ready to be able to answer your question. We are taking a short break. We'll be right back after this.
MBCI Television, transforming lives.
Kulia ni kui na kunyoroka. Nyoro. Kunyoroka? Nyoro.
I think we need to think our future.
Anataka uniseme national anthem bila kuimba. Mbio twende.
Mungu nguvu yetu. Iwe milele.
Okay.
Ilete baraka kwetu. Mimi najua tu kuimba. Najua tu kuimba. Ilete baraka kwetu, nasi ni ngao na mlinzi. Tukae na ndu.
Ajizi ni?
Hey, y'all, come look at this.
Aliyepagawa.
Aya, charger manual na automatic gani na charger haraka?
Sasa hapo sasa itavari tu na nini. Mimi nadhani na vari tunayo betri inachajiwa. voltage ya battery ni gani, sababu huwezi sema ati voltage ya ka transformer itajaza haraka kushinda voltage ya simu.
Anda zako wewe.
We believe in the extraordinary potential of every child. That is why at Greengate Academy, our aim is to equip and transform learners. Our mission is to provide high-quality education in a conducive Christian environment.
Jesus in the heart. Jesus in the heart. Jesus in the heart.
We have embraced the competency-based curriculum and have collaborated with our dedicated team of experienced educators to mine your child's potential by imparting them with relevant skills. We have incorporated a special needs program that is tailored to ensure continuous improvement for your child. Here, we encourage creativity by engaging them in co-curriculum activities like sports, games, and maximizing on digital literacy through innovation. We are keen on your child's health, thus providing nutritious meals. Transport-wise, we've got you covered. Discover the unlimited opportunities awaiting your child today. Contact us on 0702 730 987 or email us on greengateschools@gmail.com. Enroll your child today and let their journey of a lifetime begin. Greengate Academy, raising the standard.
Adui aliomba anisia gasi yage kama ngano, lakini Yesu aliomba mimi nisimame kwa wema wake.
Hujambo shabiki wangu, kwa majina naitwa Edith Wairimu na mimi ni mwokovu na muimbaji wa nyimbo za Injili. Kuna huu wimbo niliowimba Nitasimama, na ukitaka kubarikiwa nao kama Skiza Team ndani ya simu yako, tafadhali chukua simu yako ubonyeze *811 *901 #. Narudia tena *811 *901 #. Endelea kubarikiwa na kutizama MBCI TV.
MBCI Television, transforming lives.
Right, welcome back, dear viewer, on the Legal Friday on MBCI TV.
Legal Tuesday.
Yeah, Legal Tuesday. And Mangicho, labor laws,
yes.
I think we are going to deal so much on that. And you know the Atuoli team?
Yes.
they are very popular in terms of fighting for the labor laws in Kenya, yes. But basically it's a combination of trade unions. And I think we need to understand from Wakili, where do they come in? You know, we hear of COTU, it's made up of many trade unions. When should we join trade unions? Is it mandatory? Things like that.
Yeah. Yeah.
So, Wakili.
Yes.
Trade unions.
Yeah, trade unions. Let me begin with Article 41 of the Constitution. It provides that every person has a right to form and join a trade union of their own choice. It is called the freedom of association. So that is a right which is provided for under the Constitution. When you get into the Labor Relations Act, it also reinforces the right to join a trade union. By the way, even what do we call them? Employers, they also have a right to form their own organizations. We call them employers organizations. So it cuts both ways. Employees, you have a right to join a trade union. Employers also have a right to join an employers organization.
Is it like the, is it an example of what the Federation of Kenya Employers?
Yeah, the federation, that is...
that is different.
No, that is a federation.
That is a federation.
Because that brings so many employers, trade unions together. Like KOTU.
Okay.
KOTU is the umbrella union which carries all trade unions. Yeah.
Wow. Wow.
So KOTU is actually like a federation. It is an organization which is made up of so many trade unions.
Okay.
Yeah.
Now, again, why should we have these trade unions in our organizations? Why should an employer join a trade union?
Let me put it this way. At the beginning, I mentioned that when you form a trade union, and the trade union are formed on very wide sections, like the teachers, the lecturers, they have their trade union. And basically, the work of the trade unions is to protect the rights of the employees.
Okay.
That is where you negotiate terms and conditions of employment.
Who negotiates?
Now, the union officials. Yeah, they negotiate. And remember earlier I mentioned that where a trade union negotiates terms and conditions of employment which are better than the statutory ones, then they form part of your contract of employment, like issues of leave. A trade union might be able to negotiate and say, we want our workers to enjoy 36 days of leave every year, whereas the statutory period is 21. So if as an employer you have recognized the trade union, then you will give employees 36 days of leave as opposed to the 21 which is provided for under the Act. So the trade unions normally negotiate issues to do with leave allowance, house allowance, study leave. So basically it is to improve the terms and conditions of employment of workers. Same thing with employers' organizations.
Yeah.
You know, like as a trade union, you might demand an increase of salary which is untenable.
Yeah.
So the work of the employers' union is also to come together and say, if we are confronted with this kind of a situation, how do we deal with it so that we do not go bankrupt by agreeing to pay salaries which are untenable.
So I'm really suspecting something. Could it be that the employers, through their federation, can come up with the salary cut line?
No, they can't, because number one, we have a minimum wage which applies across the board. So when you are negotiating, you negotiate above what is provided as the minimum. Yeah.
Okay. And Wakili,
yes.
Even as we talk about the issue of trade unions, what does the law say, or how does the law envisage about different companies, different organizations? Of course, we know there are those who work like the civil servants, there are those who work for private companies and private organizations. Are there organizations that are exempted maybe from allowing the employees, their workers, to have trade unions?
If you look at the Employment Act and the Labor Relations Act, those acts do not apply to members of the disciplined forces. Yeah, the army, the police, NYS. Those ones can't.
For very valid reasons.
Yeah, they can't form. They can't form trade unions.
Yeah.
Yeah.
Okay.
Yeah.
Okay.
So there's a good reason why that has been put. Yeah. But then trade unions are organized in very broad areas. Yeah, like the agricultural sector, like doctors, lecturers. So they are organized in very broad areas.
Yeah, because there are people who normally feel that maybe sometimes the trade unions would come and maybe would look like maybe they are interfering with maybe a particular company's objectives and goals and maybe how it wants to run its affairs, and so many people and maybe some other organizations would feel very insecure to have them.
No, it is not. Remember, the Constitution provides for freedom of association. Yeah. So here are workers who have come together. They're forming a union. It's for a legal purpose. Okay. Yeah. So you can't really complain that the trade union will be interfering with the affairs of the company. That is why we have the process of negotiation. You negotiate the terms of the collective bargaining agreement. Once you agree, it is registered before the Employment and Labor Relations Court, and then it becomes law. Okay. If you fail to agree, again you take the issue to the Employment and Labor Relations Court. It will settle the terms of the collective bargaining agreement. Yeah.
Oh.
Okay. And there's one term which is very popular when it comes to every Labor Day, which you have just mentioned, the minimum wage. And many people hear about we are pushing for the increment of minimum wage. Even the workers themselves don't know what is this. Maybe to a layman, you may explain to us what is a minimum wage, and does it affect the casual laborers or informal employees or formal employees?
We have two wage orders, the general wage order and the agricultural wage order. The agricultural wage order applies to people who work in the agricultural sector, and it provides from general workers, drivers, and every kind of category. Same with the general work order. But then when you come to the general work order, it is classified. There's a minimum wage for those people who work in cities. There is a minimum wage for those who work in municipalities. And there's a minimum wage for all other towns. Yeah. So normally, every Labor Day, either the minister or the president increases the minimum wage. So again, as an employee, it depends on which class you fall under, because that wage order has classes. There's a driver, there's a general worker, there's a cook, you know, there's a waiter in a restaurant. So all those various classes have been provided for. If you go to the agricultural sector, there's a general laborer, there's a tractor driver, there's a loaded driver. All those categories, there's a watchman, all those categories are provided for there. Yeah.
Do this presentation that you're making touch the civil servants, or does it touch private organizations or maybe the public servants?
No, it touches everybody. It touches everybody. Yeah, it is a minimum wage which cuts across the entire country. Yeah. So you can't say, for instance, that you are employing somebody in the public service and pay them below the minimum wage. That would be illegal.
Sure. And when we come to actually looking at how the law protects some of these trade unions, because we've had also information, and we know we've seen even in our news items whereby there are people who have actually complained that there is a way maybe in which some very powerful forces, others maybe even blaming the government of actually interfering with some of these trade unions, because maybe there is a way in which maybe the government wants to have its way. How do you think the law is effective enough to ensure that some of these movements, some of these unions are protected?
All right. Under the Labor Relations Act, there's a legal framework on how to register a trade union, under what circumstances a trade union can be registered. Okay. Yeah. Of course, politics comes in. If say the government is not happy about a trade union, or if some politician is not happy, they might bring in some politics, which may lead towards the registration of a particular trade union. But those cases are really very, very, very rare, because the Labor Relations Act is very clear on the procedure to be followed when you want to deregister a trade union. Yeah.
Wow.
That act also provides for the process of registering a trade union. Maybe the bigger question would be if the registrar of trade unions refuses to register your trade unions for reasons which you think are not valid, but then of course the courts come in. Yes. You can go to court and say, I was registering a valid trade union. The registrar has refused to register it because of reasons which are invalid. Please set aside that order refusing the registration of my trade union.
Yes.
Yeah.
Yeah, and maybe before you come in again, what does the law also say? Because there are people also, or maybe an employee somewhere would argue that in as much as we have a group, we have a section that wants to begin a trade union in this particular organization, I don't feel I want to be part of it. Is it mandatory for one to be in a trade union in their organization or in the place where they are working, even if they feel they don't want to be there? And what would happen if they are not there and there are issues that have been presented and maybe pursued by this particular organization for the welfare of the workers? The one who is not included, will they benefit or will they be left out?
Very, very, very interesting question.
Yes.
Normally what happens is that once a trade union is recognized by an employer, then you negotiate the collective bargaining agreement,
right,
which is then registered before the court. Once it is registered as an employer, actually the Cabinet Secretary for Labor gazettes the amount of deductions which you should make from all the persons who are employees and who are members of the trade union. You deduct the money, send it to the trade union. Now, what about people who are not members of the trade union, but who benefit from the negotiations of the trade union? We have what we call agents' fees. So when the Cabinet Secretary is gazetting the deductions to be made, he also states that those people who are not members of the trade union will pay agents' fee, which is equivalent to the deductions actually made by members of the trade union. And this is done because they are going to benefit from the negotiations between the employer and the trade union.
Yes.
Yeah.
Okay.
Very interesting.
That's very interesting. And I was about to ask, but for how long should they pay that? 2, 3 months or lifetime?
No, lifetime, so long as you're employed. Yeah. So long as you're employed, you pay the agent's fee and the deductions. It's normally a percentage of your salary.
So it's just like you have joined the union indirectly.
Yeah, actually, yeah.
Right. We have a short feature from the ILO, the International Labour Organization. I want us to watch this, which talking about their push and their recommendations on the work environment.
Work. Whether you have it, you need it, or you depend on others to have it, work is central to your well-being. Work gives our lives purpose and dignity. Work gives us our humanity. Almost 500 million women and men need work. Millions more have work but live in poverty. And hundreds of millions lack the basic labor rights to give them a living that is healthy, safe and secure. The International Labour Organization is the UN agency for the world of work. It was founded on the belief that social justice is essential to universal and lasting peace. The ILO promotes decent work for all through an agenda that aims to give people a fair stake in their working lives and in society. The ILO was created in 1919 as part of the Treaty of Versailles that ended World War I, to ensure social justice for people through work. It became a specialized agency of the newly formed United Nations after the Second World War, and today has a membership of 187 countries that continues to grow. The ILO received the Nobel Peace Prize in 1969 and today is recognized as the world's authority on the world of work. Its impact is seen at key moments in history. The work of the ILO affects almost every aspect of our lives. From regulations setting out safety and health standards, through to policies to end discrimination, violence and harassment in the world of work, there exists international labor standards to protect us. Eradicating child labor and forced labor, ensuring equal pay for work of equal value, creating new and better jobs, strengthening social protection systems, helping women and men gain the skills they need to succeed at work, and upholding the rights of workers and employers, including through social dialogue. The ILO mandate is an integral part of all 17 Sustainable Development Goals, and decent work itself is Goal 8 of the UN's 2030 Agenda. Headquartered in Geneva and with over 40 field offices around the globe, the ILO is unique amongst international organizations, where not only governments, but employers and workers as well have equal voices. They work together to create labor standards and policies that impact today's global economy. Headed by a Director General, the Secretariat conducts research and data analysis about the world of work and supports the work of members and constituents. Each June, the organization meets for its annual International Labor Conference, where labor standards are discussed and adopted. Its Executive Council, the governing body, meets 3 times a year. In the field, the ILO advises governments and collaborates on projects at the country level to help put standards and policies into practice through training, education, and research. In 2019, the ILO adopted the Centenary Declaration for the Future of Work to respond to a world experiencing transformative change, driven by technological innovations, demographic shifts, climate change, and globalization. It calls for a human-centered approach to the future of work, a task made all the more urgent by the outbreak of COVID-19. The crisis has revealed a pre-existing pandemic of poverty and inequality, which must be tackled if the world is to build back better. The ILO Declaration for the Future of Work therefore sets out a roadmap for creating a safer, more inclusive and just world, with decent work for all. Globalization, disruptive technologies, rising inequality, climate change, and a pandemic. The world of work is changing faster than ever before. The ILO brings over 100 years of knowledge, experience, and achievement, as it contributes to peace and security, to sustainable economic growth, and the dignity of all women and men.
The world faces multiple interrelated crises which demand global solutions. Today, the need for more social justice means that the ILO and its mandate are at the heart of the world's concerns. We have the capacity, the energy, and the determination to translate this mandate into solutions that lead to a more sustainable, inclusive, and resilient world of work.
Correct. There we go, Wakili. And we have been talking about various international treaties on various quarters. And sometimes I ask myself, as we look at the ILO, which I think I'm going to talk in details later on, how effective is our international treaties when it comes to, for example, ILO? Maybe in your legal profession, is there any impact of the international treaties?
Okay, I think let me start by going back to before 2010, before we enacted our 2010 Constitution. Before then, for international laws to be applicable, they had to be enacted to be part of our national laws.
Yes.
For them to be applicable. And actually, if you look at the 2007 Employment Act, it was enacted before the 2010 Constitution. It has borrowed heavily from the international conventions and also ILO conventions. Come 2010, under the provisions of Article 2.5 and 6 of our current Constitution, the conventions and treaties which Kenya has ratified now form part of our laws. They do not need to be reenacted in some form of local legislation for them to be applicable. For instance, I can go to courts and say my right to organize, as provided for under the ILO Convention, has been violated because that law is part of our laws now in Kenya. Yeah.
Okay. Is there a situation whereby maybe Kenya ignores or violates the ILO? Can ILO act upon Kenya? Does it have legal powers?
No, it does not. What, if you saw from the clip, ILO works on what we call a tripartite setup. That is where it involves the government, the employers, and the employees. So in those meetings which they have, you have representatives from the government, representatives from workers, and representatives from employees. So that when they are passing these conventions, it is an issue which has been discussed by the three parties, who are the three key players in the world of work and employment. What it does, it encourages, ILO encourages governments to follow their conventions and the standards which they set. But if you do not follow them, ILO on its own does not have the mandate to enforce those standards and conventions.
And maybe finally, maybe there's a country, maybe Kenya, we respect those international like ILO. There could be a country which does not respect its internal labor laws. Is there a way whereby ILO can come in to be able to rescue the situation, whereby there has been violations of child labor, misuse of laborers and workers, not only in Kenya but globally?
No, ILO cannot, but interested parties can file cases like, say, in the International Court of Justice and say this country is violating these rights, and the ICJ can pronounce itself on the particular violation which is happening regarding the issue of labor laws. Yeah.
Okay.
Wow, that's quite interesting. I've actually loved that narration, that short documentary there, and actually even helping us to get a glimpse of what the ILO actually does. And maybe, Wakili, when we look at this particular organization, also in relation, because now we are saying the world has become a global village in the world of technology, and you'll find that different people, maybe from different countries, in different times might find themselves working in different areas. How does one now know that they can be assured of actually being protected by labor laws in their country, and when now they have also moved maybe to work in another country, which happens it's quite common today.
If you go to the ILO website, it has a very good database showing all the conventions and showing the status of ratification by each of the countries. Okay. So if, for instance, I'm going to work in Uganda, I can go to the ILO website and check which conventions have been ratified by Uganda. Also check their local laws to see how they have been incorporated into their system. Then you'll know that if I go to work in Uganda, I'm actually protected under the ILO conventions. And again, you may need to familiarize yourselves with the labor laws of that particular country where you're going to work, because each country has its own laws.
Okay.
Yeah.
Awesome.
Okay. And maybe we can now slip back again to our main topic regarding to the employment. Which procedure should an employee maybe follow when you want to lodge a complaint? Maybe his or her rights have been violated at work.
That entirely depends on the nature of the violation. We have the Employment and Labor Relations Court, number one, which can hear cases of violation of fundamental rights and freedoms under the Constitution.
Yeah.
So if you feel that any of your rights under the Constitution, especially those provided for under Article 41, are being violated, then you can file a petition before the Employment and Labor Relations Court. If it is an issue regarding dismissals, unfair dismissals, unfair termination, then those ones you can file those claims in the Employment and Labor Relations Court. Now, I think in 2018, the Chief Justice, through a Gazette notice, appointed several magistrates to hear employment and labor relations matters where the gross salary, monthly salary, does not exceed 80,000. So if your salary is less than 80,000 and you have an issue with the termination and payment of wages, then you file your complaint before the Chief Magistrate Courts, the labor section, so long as your salary is below 80,000 a month. Yeah.
Yeah.
And again, maybe you can also actually complain to the labor officer. Labor officers have several powers. If you have a complaint, you can lodge your complaint to the labor officer from your local area.
Oh, where are they stationed?
We have county. Every county has a labor officer. Yeah.
Okay. Sawa. Mangicho, before we continue, we need to check a little bit of the landmark ruling and we need to see how this is happening. Again, we are going to look at the international labor organizations, how they handle the child labor declaration, because this has become one of the thorn in the flesh with many people. And the child labor is work that interferes with the physical and mental development of children. And there was a declaration agreement that all ILO member states have an obligation to respect, promote, and realize the obligations, obligations of child labor, and even if they have not ratified the conventions in question. Okay, and we say that there are still 168 million children working worldwide. 168 children working worldwide, 85 million in a very unpopular conditions. Examples, slavery has been mentioned as one of the exploitations of child labor, commercial sexual exploitation, illicit activities, and hazardous work that is likely to harm their health, safety, or morals. We have one of the declarations of ILO regarding to how we should be able to understand child labor. If you are there, you hear about child labor, you don't know what it is, Here is what ILO had to tell us.
Whilst children toil in situations of slavery, or people are trafficked to work in foreign places, we know a better world is possible. But to change, we first need a shared understanding of what we want to change. How we define the problem can determine if and how we solve it. The International Labour Organization has created clear definitions of forced labour, providing a critical foundation for research and evidence-driven policies. The ILO Forced Labour Convention, number 29, defines forced or compulsory labour as all work or service which is exacted from any person under the menace of any penalty, and for which the said person has not offered himself voluntarily. Menace of any penalty refers to the means of coercion used to impose work on a worker. Involuntary work refers to any work taking place without the free and informed consent of the worker. Both conditions must exist for a person to be statistically regarded as being in forced labour. A child is considered to be in forced labour if she or he performs work under coercion for a third party, or with a parent who is in forced labour, or if they are in the worst forms of child labour, except hazardous work. There are two types of forced labour: state-imposed and privately imposed forced labour. Within these types, forced labour may take different forms, such as bonded labour, trafficking for forced labour, and forced commercial sexual exploitation. Clear and universally agreed definitions can help researchers confidently measure forced labour. Measuring forced labour allows researchers and policymakers to understand the extent and characteristics of forced labour. Forced labour may be measured using a single data source or a combination of data sources. Data sources can involve household surveys, establishment surveys, or administrative records. It is important to follow strict ethical guidelines when doing research on forced labour. Data on forced labour plays a key role in guiding policy. To make progress on SDG 8.7, we need more and better data and research on forced labour to inform policy actions. Together, we can build a better world.
Yes, that's quite a very, very interesting exposition there, Kagi, especially looking at the child labor issue. And of course, I think we also talked about this, I think, in one of our episodes right here when we were looking at issues to do with the children's rights. But then if we can actually maybe bring Wakili into this, when you talk about employment and labor laws, someone who is supposed to be employed, what age should they be?
Interesting question. If you look at, I think it is Part 6 of the Employment Act. It provides for protection of children's rights.
Okay.
The minimum age for which you can employ a child is 13.
13?
Yes.
Yes.
Children between the age of 13.
So you can employ a child?
Yes.
Okay.
Employment of children between the age of 13 and 16 can be employed so long as that employment does not affect their going to school and is not hazardous to their health. Yeah.
Will you need some permission from their parents?
The law is silent. The law is silent on that, whether you need a permission from their parents.
Or from their guardians.
Or from their guardians. But then, if you look at the Children's Act, those are minors. They are under, there's somebody who is, they are under somebody, either parent or a guardian. Naturally, then it follows that you need to seek consent of either the guardian or the parent before you employ them. And I think the employment which is envisaged here is very light work, not permanent employment, doing very light work, especially when the Act states that it should not interfere with their going to school. So look at it. When will you employ this child? Maybe during holidays only.
Like right now.
Yeah.
When they're at home.
Yeah. And then maybe doing very light work. Yeah.
Does it also specify the kind of remuneration?
No, it doesn't. It doesn't state the remuneration. It just, the Act provides for the conditions under which you can employ children under between the age of 13 and 16. Of course, they are not supposed to work in mines, and those other hazardous places.
What would happen if maybe one was to launch a case that maybe the children, they were paid quite a lot of money, and maybe it violated their rights?
By paying them a lot of money? Would that be violating their rights? I don't think so. I don't think so. What's the complaints which we normally have is, and here is where I think as Kenyans we have failed. Of course, we know there are children who are employed under circumstances which violate the law. So the Act requires that if you are aware of such a case, a report to a labor officer or to the police. They will investigate, and whoever is involved should be punished for that crime. And that is the only way we can deal with a violation of children's labor rights.
Wow.
Yeah.
Interesting, Kagi.
I think two areas where these rights are heavily violated is where we are dealing with the house managers vis-a-vis the maids and the farm workers.
Yeah.
If you go there, you'll find there is a lot of child labor and forced labor. I don't know how this can be tackled. It has been a huge task, isn't it?
Yeah. Like I've said, we have a very good legal framework protecting children, protecting forced labor. But the major problem we have is enforcement. Yeah. You see, the people who are supposed to report are the beneficiaries. So they will just keep quiet because they are beneficiaries of the labor. So you will find that very few cases of child labor are reported, very few.
Yeah.
But where they have been reported, action has been taken. Yeah.
All right. Mangicho, do you have any legal jargon today?
Of course, like we always do. These jargons and terminologies are quite a number, Kagi.
Yes.
We cannot exhaust them, and of course we also have one for our viewer today, and our Wakili is here. He'll also have an opportunity to break it down for us, definitely. And of course, welcome to the legal terminology for today. Our legal terminology for today, it's the term prima facie. Prima facie is a way to evaluate a case. When you talk about prima facie, is a way to evaluate a case at an initial stage to see if there is enough material for it to go to trial. That is in both civil and criminal law. The term is also used to denote that upon initial examination, a legal claim has sufficient evidence. Legal claim has sufficient evidence to proceed to trial or judgment. That is what we mean when you talk about prima facie. So it's a way to evaluate a case at an initial stage to see if there is enough material for it to go to trial in both civil and also in criminal law. And of course, the term is also used, or we can also use the term to mean or to explain or to denote that upon initial examination, a legal claim has sufficient evidence or enough evidence to proceed to trial or actually to proceed to judgment. So, Wakili, welcome to this particular terminology that is prima facie. You interact with this particular term, but if you can help our viewer to break it down for us, and maybe in relation to some of the cases that one may want to actually to apply this particular term.
Yeah, the term prima facie, if I break it down, it means on the face of it. On the face of it, prima facie.
Prima facie. Yes.
We normally use it when we are applying, when parties are applying for injunctions. Yeah, for you to get an injunction, we normally say you must establish a prima facie case. That is, I look at your papers before I look at the papers of the opponent. I can see that you have a case which, on the evidence before it, which may succeed, but not necessarily that it will succeed. So you're saying, on the face of the materials before me, I think this is a case where I should grant an injunction.
That is the judge, the magistrate?
Yeah, the magistrate or the judge who is looking at your case.
Oh,
yeah.
So they're the ones who declare a particular case to be prima facie?
No. They're the ones who decide whether, from the papers which you have presented, you have presented a prima facie case which warrants the grant of an injunction before either hearing the other party, or if when you have heard the other party, whether you have established a prima facie case to warrant the grant of an injunction pending the hearing of the dispute between the two parties. Yeah.
And will it be the role now of the advocate or the lawyer now to request the magistrate to consider that?
Yeah, those are the submissions we make, that from the papers which I have presented in court. The plaintiff has established a prima facie case. So if we have established a prima facie case, then give us an injunction.
Give us an injunction.
Yes.
Kagi, and there you go. That is prima facie.
Yeah, very beautiful. I think next time you can bring a more relaxed term. As long as I'm trying to groom myself to become a legal mind, you know, it's becoming difficult, Mangicho.
You can give it a try.
But you are learning new terminologies and jargons from our courts. And I was thinking of how do our young legal minds do these things? You're fresh in court. Sometimes they get challenges to interpret these terminologies. Yeah,
not quite, because these are terminologies students learn all the way from law school when they do pupillage. They're not really very hard terms. As a lawyer, once you've been admitted and you're practicing, you should be able to know them. Actually, as lawyers, sometimes we say we are trained to find where the law is. So if you find a term which you do not understand, it is quite easy for you to go and find out its meaning and apply it.
All right. Yeah. Nice. At this juncture, we want to look at the inside law. Today, again, I want to go back to ILO, but talking about the ILO Declaration on Fundamental Principles and Rights at Work. Today, we are really dealing with employees and how your rights as a worker should be respected. And as we just said before, that the ILO, the International Labour Organization, is a UN agency whose mandate is to advance social and economic justice by setting international labor standards, and this ILO is a major contributor to international labor law. One, it meets 3 times a year, I think between March, June, and November. It takes decisions on ILO policy, decides on the agenda of the international labor. ILO is a specialized agency of UN, and it was adopted in 1998 and amended in 2022, as you can see here, an expression of commitment by governments, employers, and workers' organizations to uphold basic human values that are vital to our social and economic lives. All right? ILO has adopted and supervises the application of the International Labour Conventions, and other important ILO standards deal with conditions of work, including the wages, hours of work, but these standards are not considered fundamental or core conventions. But ILO is really looking forward for the following issues which comes up to be their functions. Number one is freedom of association and the effective recognition of the right to collective bargaining, to be able to get the right maybe pay, the elimination of all forms of forced and compulsory labor, and effective abolition of child labor. It has also a function of eliminating or discrimination in respect to employment rights. No one should be discriminated. A safe and healthy working condition Anybody who is working must be given a safe working condition and also accessible, productive, and sustainable work worldwide in conditions of freedom, equity, security, and dignity. The right of workers to associate freely and bargain collectively is another function which we had mentioned before, and to end forced and compulsory labor, and to end unfair, discriminating, and maybe to every worker. But finally, to say the ILO has all the legal obligation to see kwamba in this global, every worker's right has been respected. And Wakili, as you said before, is that we have heavily borrowed from these ILO recommendations, right? Yeah, and of our Inside the Law, we are coming back with a little bit more. I don't know what Wakili you can say about the ILO declaration.
I think the ILO declaration has contributed very heavily towards the development of our labor laws in Kenya. And I can almost confidently say that in Kenya we have local laws which have adopted those ILO conventions, and I think we have laws which respect the rights of workers, the rights of employees, and I can also state that we have the tripartite arrangement, that is between the government, the workers, and their employees, who meet and discuss these labor issues. So all in all, I can say that Kenya has adopted and has embraced what has been provided for and by the ILO.
Very well.
Yeah.
Mangichu, today, who is in the profile?
Yeah, of course, we also have profile. Our legal profile for today, as we always do in this particular show. And I know this is a very common figure, Kagi, none other but Amos Wako, making for us our legal profile for today. And of course, as you can see on your screen, Amos Wako, born on 31st of July 1945, educated at Kakamega High School and also Alliance High School, holder of Bachelor of Science in Economics from University of London, and also a holder of Bachelors of Law from the University College of Dar es Salaam, Masters of Law from the University of London. He was also the Secretary General of the African Bar Association, that is from 1978 to 1980. Amos Wako was the Attorney General of Kenya from 13th of May, that is 1991, to 26th of August 2011. Actually, during this particular time or period, he oversaw the transition from one-party state to the era of multi-party democracy. And he transitioned also from KANU regime under Daniel Moi to NAC regime under Mwai Kibaki. He was very instrumental in that. He served as a senator for Busia County from 2013 to 2022. That is the profile of one Amos Wako. But of course, mainly remembered as the Attorney General, who served for a very, very, very long time.
And, yes, and they call him the ever smiling. And surely he is ever smiling.
Yeah.
Yeah. But I love the way he stipulated his legal work from the middle to high level of our corridor of justice. Yeah.
What do you remember him for, Wakili?
Mainly his participation in the enactment of the current constitution. He played a very critical role in ensuring that we transitioned from the old constitution to the new constitution.
Yeah, actually very important when you're mentioning that, because it's credited with those two main transitions from the one-party state in the early 1990s to multipartyism, and of course now when we were coming from the Moi regime to the Kibaki regime, again, it was a major transition. So how crucial, how critical is the office of the Attorney General when we're having this kind of transitions?
And also the promulgation of the new constitution.
Of the new constitution, yes.
Yeah, you see, the Attorney General is the principal legal advisor of the government. So you really need to have your laws at your fingertips, and ensure that you provide the government with proper and sound legal advice. So you can see that as an Attorney General, you have a very big responsibility of advising the government on legal matters.
Wow.
Yes, and finally, as we wind up, you could remember the Peace Accord, the National Peace Accord between the Kibaki and Raila Odinga, the Anand team. It was very instrumental also.
Yeah, exactly.
When we had the brokering of that particular deal, post in the post 2007 violence.
Yeah, which was shared by Kofi Annan.
Yes, Kofi Annan.
Yes.
Right. I think we want to thank you, Wakili, for coming to us and talking more about the Employment Act.
Yeah. We've just touched maybe very little, Kagi.
Yes. God willing, next program, we'll be able to dig deeper on this. I want to thank you again for coming.
Yeah. Thank you very much.
Yes. And at this juncture, we want to complete and end the program. Before then, 30 seconds, Wakili, your parting shot on the Employment Act.
We have very good laws covering employment and labor relations acts. If you are a victim, please familiarize yourself, especially with employment acts. If you are not sure, seek legal advice. But we have very good laws which govern every area covering labor and employment issues.
Okay, and Mangicho, I think that's enough. We need to tell our people they need to know their rights. Yes, as citizens, if you're working anywhere, you need to understand what are your rights as an employer.
Absolutely, and of course, I know if we get another opportunity maybe next week, because we've looked, Wakili touched on the casual laborers, maybe we'll get another opportunity maybe to talk also for those who are in contract, those who are also permanent and pensionable, and so on and so forth.
And even you're doing a piece piece work, or you call it what?
Piece rate.
A piece rate. So all those kinds of employment, we need to, God willing, to dig them deeper, be able to understand where you belong and you are right. It's called the Legal Tuesday until next week, God willing. But tomorrow we are here with Mangicho with the Leadership Wednesday. My name is Paul Kagi. I'm wishing you a blessed day ahead.
Exactly, and thank you so much for making time to be with us in this Legal Tuesday edition for today, looking at the employment and the labor laws on behalf of the entire team behind the scenes, making it a success. Enjoy the rest of your viewing. My name is Mangicho Mola.